See, they must incorporate the relevant clauses in the agreement, and after the agreement, the parties must abide for, they must, if an award is passed, ultimately they must agree for the same. See, nowadays, almost all awards are being taken to the court. See, what is the purpose in referring the matter to the arbitrator? Instead of it, the regular courts can consider their claim. So that we must evolve. See, I can't say that the court's power has to be completely taken away, but at least certain factual disputes have to be settled at the arbitrator's level. And as rightly pointed out, after this Patel engineering case, now it is not an administrative order. Whatever the order passed by the Chief Justice or is designate of the High Court or the Supreme Court is a judicial order. All aspects have to be considered. Of course, now if it is an order of the High Court, only appeal lies to the Supreme Court under Article 136. In those days, prior to this judgment, the order of the Chief Justice or his designate judge was very lightly interfered by I am very lightly, in the later on I am saying, an additional judge appointed a month ago, hearing the writ petition. He used to entertain a writ petition and grant stay of the order of the Chief Justice. That was the position. Fortunately, that Patel engineering has now cleared. So my view as far as arbitration is concerned, of course the present act is very comprehensive. It depends upon the parties who avail this. So except for important questions relating to some vital aspect, legal aspects, for other factual details, they must have a satisfaction with the award of the arbitrator. And the arbitrators, most of them are from the judiciary. They must also realize the about object and policy for resorting to the other mode for solving the issue, and the advocates appearing before the arbitrators are also, they must also have a responsibility. See, I'm sorry to say, many of the junior members of the bar come and say, sir, my senior is held up before an arbitrator. See, they also treat the arbitration proceedings like a regular court. That should be avoided. And coming to the mediation and conciliation, as rightly pointed out by the earlier speakers, this mediation requires some kind of training. The mediation initially started in our country only at Madras, when Justice Markandeya Kachu, Honorable Judge of the Supreme Court, when he was a Chief Justice, he initiated this and he invited 3 or 4 experts from the United States to Madras, and they stayed nearly for 7 days, and most of the judges and several advocates had an opportunity to hear their views. And now the 3 or 4 advocates from Madras, they are attending other high courts and they are training some of the advocates how to mediate. It is an art. And as far as conciliation is concerned, my personal view is these matrimonial matters can be referred to the conciliator. See, by discussion, by conciliating, by more conciliation, the matter can be resolved. And my brother Justice Rathod has pointed out the relevant provisions from the Hindu Marriage Act, Industrial Disputes Act, and as well as CPC. It is true that the provisions are there in these enactments, but how many judges in the subordinate courts they insist the advocates and litigants to avail this remedy. When I was a judge at Madras High Court, the Chief Justice A.P. Shah, even now he is a Chief Justice at the Madras High Court, he formulated a novel method. He requested first 10 senior judges, except CJ, number 2 to number 10. Their court timing is 10:30 to 4:30. So after 4:30, the first 10 judges have to sit in the court hall. If they are in a division bench, the other judge will retire to his chamber. The judge concerned has to sit in the court itself. He collected all the original side suits that were pending more than 12 years and 15 years, listed and that those particulars have been communicated to all the litigants and the advocates a month ago, with an intimation that these cases will be shown before these judges, and the parties have to appear in person with their advocates. We, the first 10 judges, just go through the plain and written statement, and we have to convey whether there is any prima facie case, whether suit is going to be decreed or going to be dismissed with cost or not. And persuade, our endeavor is to convey this to the litigants in the presence of their lawyers, and convey our views. And we used to say this is only a prima facie view, and after evidence, decision may be changed in 1 or 2 cases. For information, I am saying 75% of the suits have been settled. For example, 10% they come and reports are infructuous because filed in 12 years back, 13 years back, I am not interested. So 10% of the cases have been removed from that list. The remaining 50 to 60%, by our efforts, they agree for settlement. So even the courts can, this we as a High Court judges, we convey it to the subordinate judicial officers whenever they come for a training or some meeting in the judicial academy. So if this method can be followed by the subordinate judicial officers also. And the Legal Services Authorities Act, see, everybody feels that only these commercial litigation, commercial cases have to be given importance because so many big companies are coming to our country, forgetting our own citizens. Kindly check up the statistics of the high courts and the subordinate courts. How many ordinary civil suits, bar injunction, mortgage, partition suits are pending for more than 10 years and 15 years. And the motor accident cases, cases under WC Act and the cases under the Matrimonial Act. Now, before proceeding further, I will give one illustration in respect of the earlier subject. When I entered the bench in the year January 1996, within a short span of time, I had an opportunity to hear a regular second appeal. At Madras, we call second appeal, in other places RSA. It is a dispute between, it is a partition suit, dispute between two brothers. The subject matter is very, very, very simple. They were having 7 palmar arteries. These poor fellows, they are not able to divide how the palmar arteries have to be sorted out. They filed a suit. Then one suit decreed. The other man not satisfied, filed appeal. Then a second appeal. When the second appeal was listed before my board, I was about to take up the matter. I saw the counsel appearing for the appellant. One of the brother was my teacher. I learned Hindu law from him. He was having more than a dozen books, including All England Reporter, etc., for this final degree proceedings. Then the other side also, I verified a leading senior advocate. I asked them whether you have brought these books for this case? Yes, sir. That is the reply from a respected senior with whom I learned law. Then I said, sorry, sir. I'm sorry, I won't hear you. The point is very simple. I have read the papers. Only thing we have to see how these 7 Palmyra trees have to be divided. No, I can't. Very simple. Within 2 minutes, I will convince both of you. I will fix the value of the trees. One can take all the 7 trees. He has to pay the amount, and the other brother can take it. Why all these laws, particularly All England Reporter, Halsbury's, not required? Then the senior advocate said, sir, you appoint an advocate commissioner, let him go and value the Palmyra trees. Immediately I retorted in a humble way, sir, I come from a village. I know the value of Palmyra trees. Why should these poor brothers send another 5,000 rupees for advocate's fee? I know the value, I will fix it up. Then I fixed the value. Then he agreed, because both the advocates know that I come from an agriculture family, I know the value of Palmyra tree. Then ultimately they agreed. They were happy. The younger brother agreed to pay the amount, and another brother agreed to take the Palmyra trees. So why I am pointing out, we must have this kind of tendency in everywhere, from Municipal Court to Supreme Court. So if the judicial officers have this kind of knowledge, we can sort it out, one branch of litigation. Then coming to these motor accident cases, the best forum is the Lok Adalat. See, here also, our state, I'm proud in mentioning it, the Tamil Nadu is a forerunner in this Lok Adalat. Be settled. If you verify the statistics, there the habit is the High Court judge has to visit his administrative district once in a month. I visited several districts. I have to sit as a presiding officer. I have to select one reputed, respected senior member of the bar, one another person from a social organization. Then there itself we decide 50 to 60 cases. Every sitting, once in a month we visit. So these motor accident cases, the Lok Adalat is the best forum for deciding. Here, I just informed the August gathering. I don't know whether my message will go to the state governments. You know, the government is a litigant. More cases are being filed by the government in land acquisition matters for anything. They need not pay court fee. They are exempted from paying court fee. And the last line will say, on the memorandum grounds of appeal, as per GOMS so and so and so, the government need not pay any amount. So they file appeals against all the awards. That's why hundreds of thousands of appeals are pending in various high courts. So if the government and the government organization, these statutory bodies, if they come before this Lok Adalat, no difficulty in motor accident and land acquisition matters. Law is clear. Every aspects have been settled by the Supreme Court. Then this matrimonial and traffic challans. So here also in criminal matters, of course, if it is non-compoundable, the court has no power to go into these aspects. But thousands of traffic cases are there in all cities. Those cases can be referred to this Lok Adalat, and the poor fellows, they are ready to pay and get rid of this issue. And matrimonial also. See, in some states are not having family courts. For example, in Punjab and Haryana, in whole of country, Punjab is contributing more matrimonial disputes, because they get employment in States and Canada as well as UK. They